Yes, we are live.
Okay, great. I'll turn it over to Judge Middleton to get us started. Thank you.
All right, good evening, everyone. Thank you for joining us. Today's date is September 9th, 2025, and we truly want to thank every member of the Maryland State Commission on Criminal Sentencing Policy Commission. Tonight, I know you all have reviewed the agenda. It is a hearty one that the subcommittee has been spending a lot of time as well as the staff to prepare us on. So I will turn it over to Dr. Soule. I do want to say one thing before we get started. I reviewed the materials I know everyone has, and I just do want to commend the subcommittee for all of the hard work they did on these topics, as well as the staff for all of the additional follow-up work that they've done so far. So I just want to commend you all, and I look forward to having a wonderful meeting. I'll turn it over to Dr. Soule.
Okay, thank you, Judge Middleton. We appreciate that. I think the first step, which I can go ahead and do if that's okay, is just to call for the approval of the minutes from the July 8th, 2025 meeting. Are there any questions or comments about those minutes? Okay, seeing none, can I call for a motion to approve the minutes?
I'm moving.
Okay, I heard a first and a second there. Is there any opposition to the approval of the minutes? Okay, seeing none, the minutes from the July 8th, 2025 meeting are approved. The next item on the agenda I want to talk about is the announcement of a commissioner reappointment. I'm very happy to share that Robert Harvey, our state's attorney representative from Calvert County, was recently reappointed to another 4-year term on the Sentencing Commission, and we are very grateful that Mr. Harvey has agreed to another reappointment, and the governor's office agreed to reappoint him. So effective July 1, he was reappointed for another 4 years through June 30th, 2029. So thank you, Bob. We really appreciate everyone's involvement with the work of the commission, and especially those that are willing to continue to serve. So thank you so much for that. Okay, we will now turn it over to the guidelines subcommittee report. Judge Shaw, do you want to start off with any introduction with regard to the guidelines subcommittee report, or would you like the staff to just jump right in with introducing the topics?
I think we can go right to the staff report and then I'll follow up.
All right, thank you so much. So the first item on the agenda is the proposed revisions to the guidelines instructions for scoring psychological victim injury. And I'm going to turn it over to our graduate research assistant, Julia Casparo, to introduce this topic for us.
Thanks. The corresponding meeting memo for this item is titled Proposed Revisions to the Guidelines Instructions for Psychological Victim Injury. To provide everyone with a brief recap of the prior discussions related to this topic, the psychological victim injury instructions were first brought to the attention of the Commission by 2 judges from the First Judicial Circuit who asked Dr. Soule at a guidelines feedback meeting if the Commission would consider automatically assigning permanent victim injury points to sexual abuse of a minor. At its April 28th meeting, the Guidelines Subcommittee discussed the possibility of assigning permanent victim injury points to sexual abuse of a minor as defined in Criminal Law Article 3-602. 2 guests were invited to share their perspectives on the issue, Mr. Michael Calabrese, Senior Assistant State's Attorney in Wicomico County, and Mr. Brian Shefferman, President-elect of the Maryland Criminal Defense Attorneys Association. The subcommittee acknowledged the unique nature of injury to a victim of child sexual abuse. However, concerns were raised by the proposal to automatically assign permanent victim injury points to all child sex abuse cases. The subcommittee decided to table the issue until reviewing additional information from staff. In its June meetings, the subcommittee reviewed staff's proposed language to revise the instructions for victim injury and offered edits. However, the subcommittee expressed concerns about carving out a rule specific to sexual abuse of a minor when similar arguments could be made for other victims. Accordingly, the subcommittee asked the staff to further research this issue and to provide an overview of how other jurisdictions address victim injury, while also offering a broader definition of psychological victim injury that could apply to all offenses. Pages 2 through 4 of the memorandum provide an overview of how other states score victim injury. Of the 17 jurisdictions with sentencing guidelines, 6, including Maryland, account for victim injury, these being Alabama, Massachusetts, Michigan, Virginia, and the federal system. Alabama and the federal system only account for physical harm, while Virginia, Massachusetts, and Michigan include psychological harm in their definition of victim injury. Virginia's guidelines require proof of the victim receiving verifiable counseling from a licensed professional, and similar to Maryland's, expand this to include rape crisis hotlines, clergy, and school guidance counselors. Massachusetts incorporates psychological injury into 3 of its 4 injury categories, omitting it from its definition of permanent injury. And Michigan most broadly defines victim injury, having separate scales for physical and psychological harm, and further does not require verified professional treatment to score a psychological injury. Pages 4 and 5 of the memo show the proposed revisions to Maryland's victim injury definition, incorporating language from Michigan and the federal system's guidelines. They revise Part B of the Maryland Sentencing Guidelines Manual to read as follows. The sentencing guidelines recognize that not all victims have access to psychological counseling or treatment. Victims may not have been provided treatment, and the psychological impact on certain victims, for example, minors, may not manifest until later in life. Proof of psychological injury shall be based on 1, confirmed medical diagnosis or psychological counseling or treatment, or 2, other forms of reasonable proof. Rape crisis hotlines, clergy conferences, educational counseling, and other similar services are considered psychological counseling or treatment. Permanent psychological injury shall be based on proof of a substantial impairment likely to be of an extended or continuous duration. The proposed changes to COMAR are on page 5. And lastly, there are also 2 appendices included in this memo. Appendix A, starting on page 6, is a table of how all jurisdictions define victim injury with links to their sentencing guidelines manuals. And Appendix B, which starts on page 11, details the U.S. Sentencing Commission's policy statement on resolving disputed sentencing factors. This is included because some of the federal system's language is used in the proposed definition of victim injury for Maryland. That concludes my summary. We're happy to answer any questions, but otherwise I will turn it over to the commission.
All right, so I do want to express our thanks to the many people who have had an impact and have given us information. As she said, it originally started as a comment or comments from assistant state's attorneys regarding victim injury and sexual abuse cases, and we began to look at that because we thought those were valid concerns. But we also received, in the middle of our discussions, we also received a comment from Judge D. Leonardo that caused us to expand our perspective on how we define victim injury. And so that's why we came up with this recommendation. I would, on behalf of the subcommittee, move that the commission vote in favor of this recommendation. Or actually proposed revisions, I guess we should say.
Right.
All right. There's a motion to approve the proposed revisions to the guidelines instructions for psychological victim injury. All those in favor? I'm sorry, is there any discussion?
Do we need a second first, Judge Middleton? I don't think I saw a
I'm
second.
sorry. I thought I saw. I
I
did
think
not.
I have
Is there a
one
second?
question.
Oh, 1 second. Is there a second?
Second.
All right, thank you. Is there any discussion?
I have one question. And I
Yeah.
just want to make sure if I understand. So in terms of psychological injury, it was the verification needed for the treatment and whatnot, but it did touch on the fact that like a minor may not necessarily be able to undergo that psychological aspect. So in that proponent, are we not assessing the score when doing the worksheet, or is it being proposed that you still do consider that in the score?
It's a consideration that you should have, but it is a recognition that in fact often occurs. Because a minor is within the care and custody of a parent or guardian who may or may not accept the validity of their complaint about abuse. And so under those circumstances, that minor would probably not have access to treatment. And so it's a recognition that that may occur and that the court should still make some considerations, potentially, not required.
Gotcha. Thank you.
Any other comments or? Yes, Mr. Harvey.
We can't hear you. I'm not sure if you're on mute. It doesn't look like you're on mute, but we cannot hear you.
We can see that you're speaking, but we can't hear you.
Now you're on mute.
Now you're on mute. So try to.
Maybe turn your volume up.
No.
It's funny though, we kind of know what you're saying because you are very animated. Do you want to go out and come back in? And as soon as you come back, we'll make sure to take your comment or
you can put it in the chat.
Yeah, you can put something in the chat if you wanted to.
He said, yeah, I'll try.
Yeah, the chat's at the bottom there. If you click on that, you could type it in.
You know, David, you might be able to send him a request to unmute, and then when he clicks on that, sometimes it unmutes.
Okay, I just did
I don't-
that.
You tried that, didn't work.
No, sorry, Bob. Yeah, you're not on mute on our end. We can see right now.
Okay. In the chat, Mr. Harvey wrote that was the reason for subparagraph 2. We allow for other forms of reasonable proof.
I think that was in response to Agent Ross's question. So exactly that. And I thought Judge Shaw did a great job of answering that. We had that discussion. The reason why these revisions are proposed as they are, we're just to deal with that exact type of scenario where, for instance, if a minor doesn't have access to treatment, so it could be confirmed medical treatment like it was in the past, Agent Ross, but the judge will allow for other forms of reasonable proof, which might be, I don't, could be testimony, speaking about the impact on the victim and the injury.
Thank you. Okay. From anyone else? All right. It's been moved and properly seconded that we adopt the recommendation of the subcommittee. All those in favor?
Aye.
Aye.
Any opposed? Motion carries.
Okay, so no votes in support, opposition, so carried. Great, thank you. Let's move on to the second item on the guidelines subcommittee report. That's proposed revisions to the seriousness categories and guidelines instructions for subsequent violations of criminal law article 4-204 and 4-306. And I am going to turn this discussion over to Catherine to give us an introduction for this topic.
Good evening, everyone. I refer you to the memo titled Proposed Revisions to the Seriousness Categories and Guidelines Instructions for Subsequent Violations of Criminal Law Article 4-204 and 4-306B. The Guidelines Subcommittee reviewed this issue at its June 3rd and August 21st meetings. Initially, the staff presented to the subcommittee the question as to whether the subsequent violation penalty for Criminal Law Article 4-204, which prohibits the use of a firearm in the commission of a felony or crime of violence, should be used to calculate the guidelines for a defendant convicted of multiple contemporaneous violations of the statute and/or a prior conviction. This is a question that staff have been receiving with increased frequency over the past several years based on case law issued by the Supreme Court of Maryland and the Appellate Court. Given the complexity of the issue, the subcommittee requested that staff seek guidance from the Office of the Attorney General. Staff sent to the OAG 4 questions. 1, when a criminal event involves multiple contemporaneous violations of 4-204, are all but the first violation defined as subsequent violations and subject to the penalty provided in 4-204C2. 2, when a sentencing event involves multiple violations of 4-204 that are part of separate criminal events, that is, committed during the course of separate criminal transactions, are all the first violation defined as subsequent violations and subject to the penalty provided in 4-204C2. 3, does the subsequent violation penalty apply to defendants with a prior conviction for 4-204, but only one instant violation? And 4, do these rules apply to violations of 4-306, which prohibits the use of an assault weapon in a crime of violence or any felony? The Commission's assigned Assistant Attorney General, Mr. Stu Nathan, responded with a letter of advice on July 7th, 2025. That letter was included with the meeting materials. Mr. Nathan answered each of the questions in the affirmative. Mr. Nathan referenced Garner v. State, the controlling case law issued by the Supreme Court of Maryland in 2015. In that case, the court held that the subsequent violation statute applied in a case where the defendant used a firearm to contemporaneously commit 2 crimes of violence against one victim. He advised that the reasoning in Garner applies to each of the Commission's questions and that the enhanced penalty provisions in 4-204 for subsequent violations applied to both contemporaneous or prior violations of the prohibition against the use of a firearm in a crime of violence or any felony. Further, given the similar language in 4-204 and 4-306, Garner would also control in the enhancement in 4-306. Given this advice, the Guidelines Subcommittee recommends that the Commission take 2 actions. First, the Subcommittee recommends the Commission provides classification for subsequent violations of 4-204 and 4-306. First-time violations of these statutes are currently classified as seriousness category 3 offenses, while subsequent violations are classified as seriousness category 2 offenses. Initially, subsequent violations were classified as one seriousness category higher than first-time violations, largely to account for the mandatory consecutive sentence requirement for subsequent violations. Per 4-204 and 4-306, the sentence for a subsequent violation shall be consecutive and not concurrent with any other sentence imposed for the underlying felony or crime of violence. However, the maximum penalties for first-time and subsequent violations of these offenses are the same, that is 20 years. The Commission also recently revised the guidelines to otherwise account for the mandatory consecutive sentence rule that applies to subsequent violations of these statutes. Effective February 1, 2024, the person completing the sentencing guidelines worksheet shall add the upper limit of the guidelines range for a subsequent violation of 4-204 or 4-306 to the upper limit of the guidelines range for the underlying crime of violence to obtain the upper limit of the overall guidelines range. Therefore, subsequent violations of these statutes are now treated differently than first-time offenses, regardless of whether their seriousness categories differ. Based on these reasons, the staff suggests that the seriousness category for both subsequent violations be reduced from a 2 to a 3. This revision is proposed so the subsequent violations would not be double enhanced under the sentencing guidelines. Tables 3 and 4 on page 5 of how the guideline would change if seriousness categories were reduced. In this seriousness category,
I'm going to ask one for one moment.
a 4-204 would reduce the guidelines from 15. Yep.
Ms. Pembroke, I'm going to stop you. I don't mean to interrupt you because it's very important information, but you were breaking up at times, and the information that you were providing, I fear may have gotten, missed in translation.
Let me take over from there if I can.
Okay.
Catherine, no, it wasn't the first one. There's some couple little blips in the audio. So I will take over from there. So I think where we were leaving it, we tables 3 and 4 on the memorandum on page 5 provide examples of how the guidelines would change if the seriousness categories were reduced. And I think the part that was getting really where the audio really broke out, the reason for the proposed revision is that so the subsequent violations would not be doubly enhanced under the sentencing guidelines. So if we look at tables 3 and 4 that provide some examples, in this scenario, reducing the seriousness category for subsequent violation of Criminal Law Article 4-204 would reduce the guidelines from 15 years to 30 years to 5 years to 20 years. So the subcommittee recommends, the second recommendation of the subcommittee is that pertains to the subsequent violations of the statutes, and that instructions be added to the sentencing guidelines manual. The staff have received multiple questions regarding these scenarios. So we think it is important and it would be useful to have language explicitly instructing practitioners that subsequent violations should be selected in cases involving multiple contemporaneous violations or a prior conviction. These instructions will help to ensure that similar scenarios are scored consistently across the state. This proposed language begins on page 6 of the memorandum. As you can see, we also included some non-substantive changes to clarify instructions for subsequent offenses and added language to COMAR that would mirror that of the Maryland Sentencing Guidelines Manual. So that concludes our summary. We are happy to answer any questions, and I'll certainly turn it over to Judge Shaw to have any input from the subcommittee.
Sure. So I think the subcommittee has done its due diligence in terms of receiving an opinion from the Attorney General's office. We also had a robust conversation about this. And I just want to be clear that we're talking about individuals who may be involved in, when we say contemporaneous, meaning that these things all may happen in what may ultimately be characterized as one criminal event, but multiple violations within that one criminal event. And so from that perspective, particularly, Mr. Fency was pretty adamant about that we don't want to double penalize individuals, particularly when it is really, in essence, one event. There may be multiple violations within that event. So that is essentially, in a nutshell, what we were trying to do. And so because there have been so many questions about it, we thought that it would not only be important to make the revisions, but also to provide additional information in the guidelines instructions so that people could be clear about how this is being handled. So I would request your favorable vote on the revisions to the seriousness categories and also to the guideline instructions.
Okay. There is a motion to adopt the recommendation of the subcommittee for revisions to subsequent violations of CR 4-204 and 4-306. Is there a second?
Second.
Thank you. Thank you. Is there any discussion? Any discussion? Delegate Bartlett, do you have discussion?
I had a question, but I figure if I study the materials long enough, I'll figure it out. So we can keep going. It's okay.
Okay.
Thank you.
If it would be helpful, Mr. Fency, do you remember the example you gave us? Because I think it's sometimes it can be a little confusing if you don't have an example. Could you think of an example for us? Maybe that would be helpful to her.
Well, if you're going to do an example, could you do it on the prior? That's what the contemporaneous I get.
Okay.
The prior, how that fits in. I don't get that.
So I'm a little confused about what example you would like
I
me to
thought
give, but
she was talking about contemporaneous. So now she's saying
Right.
prior.
Yeah, but
Because
I
I
guess
thought
what I'm
too, this
getting at is
contemporaneous might have been more difficult. I could probably give an example of a prior. So let's say you have and this I'll use somewhat of the factual scenario in Garner. Okay, so in Garner you had a person who was convicted of using a handgun in the commission of a crime of violence. Now the crime of violence in that case was a robbery with a deadly weapon, but they also shot the same victim multiple times. Okay. Now that's an example of contemporaneous. But let's say that same individual was convicted of a prior robbery with a deadly weapon, because that's a good example, right? And they used a firearm in that offense. That would be an example of a prior, right? Because they likely would have been convicted of use of a handgun in the commission of a crime of violence in that scenario also. So that's an example of a prior,
well, I guess my question is more on
how you would
what
score.
yeah, on the score of a prior.
Right. So if you look at the table. If you look at table number 4, I want to say. If you look at table number 4,
What page are you on?
I'm on
Is
page
it-
5.
Okay.
On page 5. If you look at table number 4 on page 5, let's say that individual, and this is good because they actually have something similar. The individual has use of a firearm use in the commission of a crime of violence first offense. The serious category is 3. Under the current, I'm sorry, category, I'm sorry.
It is a 3, but we are proposing to amend it to a category 2, just to be clear.
Right. What I was saying was, I thought if you looked at the current revision, the current as it stands now, the serious category would be a 2. And I thought you were proposing to move it to a 3.
Right. I'm sorry. I said it in reverse. Thank you.
I'm like, I had to study this too. Don't do this to me. Okay. So the table number 4 is the outcome as it will be. Table number 3 would be the outcome if you left it the same. In other words, the committee is moving that we change the serious category from a 2 to a 3, because otherwise the individual will be penalized twice, because the the penalty provision of the statute already requires that this individual be serve a consecutive sentence. 1. But if you leave the serious category a 2, they would have an enhanced penalty and a consecutive sentence. So they would be penalized twice. If that makes sense.
That's
I get
really
it.
That's
Yep, I
really
get
where it got tricky.
Yep.
Because this statute requires the sentence to be served consecutive. And you may recall the commission recently changed the rules and said that when the statute requires the sentence to be served consecutive, the upper limits of the guidelines get stacked. We changed that rule about a year ago. So the guidelines are already going to get stacked because the statute, there's about 10 statutes in the Maryland Code that require that. This is one of them, 4-204 and 4-306. But then the question where it really got tricky, which I think we've all come around to, was like, what about when you have multiple handgun crime of violence in the same sentencing event? And the Gardner says that the second of that is a contemporaneous one, has to be scored as a subsequent violation. So they would basically get stacked within that sentencing event. If it's a true prior, meaning it happened, the offender has this prior subsequent crime of violence and now gets sentenced again for another violation, and that's on his record, then how the guidelines are treating that really doesn't come into play, because we're not stacking within that individual event.
Okay, that's what I was confused. The prior was messing me up. I wanted to know like how far back. That's why I was getting a little confused. It's fine. You all have clarified it. Thank you very much. I appreciate it.
Okay. All right. Yes. Was there any additional questions or? Okay. All those in favor? Any opposed? We're missing someone.
Judge
Okay.
Saunders, is that opposition? I see your hand. I was for in
Okay.
favor. Thank you.
All right.
Thank you for clarifying.
All right. Motion carries.
All right, great. We'll move on to the third item on the agenda for the guidelines subcommittee, and that is the proposal to study potential revisions to the scoring of physical injury. So when the guidelines subcommittee completed its review of psychological victim injury during its August 21st meeting, which we already talked about tonight, the subcommittee noted as a next step that the commission should consider revisiting the guideline scoring instructions regarding physical injury. Mr. Fincy noted that from his point of view, the sentencing guidelines instructions regarding physical injury are vague and may not be particularly helpful or useful. Specifically, Mr. Fincy referenced the guidelines instructions that indicate that injury should be more than minimal and suggested that it may be helpful to provide clarifying language and offer a definition of what constitutes more than minimal, what is permanent physical injury other than death. So the guidelines subcommittee members agreed that the language should be reviewed, and we are asking the commission to assign this topic back to the subcommittee to review in more detail to bring forward to the full commission at a later meeting.
All right.
So I would just ask Mr. Fincy to make some comments with respect to this issue, to bring
Thank
some
you,
background.
Judge. Thank you. I can say from experience that the court has difficulty determining what is more than minimal injury, what is no injury, and what is to be scored as permanent injury from multiple sentencings where that has been at issue and where the court has asked, well, what does more than minimal mean? Is a bruise more than minimal? Is a broken arm more than minimal? For the former, I would argue no. For the latter, I would argue yes, it is more than minimal, a broken arm. But so what is there in between? What should be the standard that the court should apply in deciding this important point in a case with respect to physical injury? So as we looked at psychological injury, it seemed to me the time to also bring up establishing better definitions for physical injury and to improve this entire part of our guidelines. So that's really where it comes from.
All right. Thank you for that.
So with that, the subcommittee is requesting approval to move forward with just examining at this point. We may ultimately come up with a recommendation, but at this point, we just like to examine the issue and come up with hopefully some additional recommendations that will clarify this area.
Is that for, I have a question. Is this for any particular offense or just in general?
In general. But
Okay.
if you have a particular concern about an offense, we certainly would be open to considering that.
I don't, but I do like the fact, or at least can appreciate the fact that you all included the federal system's definition of physical injury, which is on page 2 of the committee report. As a
So,
start.
so if your question is, are we going to look at various jurisdictions?
No,
absolutely.
No. Okay, good. Okay. All right. And what came to mind is first degree assault, because that's where we always get into the stickiness of what is a serious and protracted injury or disfigurement. Okay. All right. It's been moved to that we send the issue of physical injury or defining physical injury to the subcommittee so that they can do a deeper dive into its definition and what's required to prove physical injury for purposes of scoring the guidelines. Is there a second?
Second.
All right, all those, any discussion, further discussion? All those in favor? Any opposed? Motion carries.
Okay, moving on, we will move to the executive director report. I have 4 items to report today to review. The first item I want to review is new features in MAGs. On August 26th, the Sentencing Commission released new features in version 13.0 of the Maryland Automated Guideline System. These new updates include an improved display of the offender score screen and a new alert message notifying the guidelines worksheet preparer of missing home detention information. And a more detailed description of these new features is provided in the What's New in MAGs document. And we distributed that document to all of our MAGs users in coordination with this release on August 26th. The second update I want to report is the forthcoming November 3rd sentencing guidelines and offense table updates. Proposed COMAR amendments were published in the August 22nd, 2025 edition of the Maryland Register. These proposed amendments modify Regulation 12 under COMAR 142201 General Regulations, and this is in response to Senate Bill 152, House Bill 89 from the 2025 session, which provides that each animal harmed in violation of the criminal law article, Title 10, Subtitle 6, Annotated Code of Maryland, shall be considered a victim for the purposes of applying the multiple victims stacking rule. Additionally, the proposed amendments modify Regulation 02 under COMAR 142202, which is the criminal offenses and seriousness category section. These amendments reflect new and revised penalties from the 2025 session and the corresponding seriousness categories assignment by this commission. There are also other minor edits to the table, including the addition of new CJIS codes for several existing offenses. These proposed amendments are expected to be adopted effective November 3rd, 2025. The third item I would like to report in is sentencing guidelines training and judiciary feedback sessions. Our training coordinator, Catherine Pembroke, will host multiple training webinars upcoming here soon, starting tomorrow and also on September 19th. Catherine will provide an orientation and training for judicial law clerks and judicial staff, which is great timing with turnover of law clerks typically happening at the end of August and the beginning of September. Additionally, on September 12th, the Sentencing Commission will offer a guidelines refresher and MAGS 101 webinar for all justice partners, including prosecutors, defense attorneys, and probation agents, anyone who is initiating the sentencing guidelines worksheets. With respect to judiciary feedback sessions completed since our last commission meeting in July, I recently met with the circuit court judges in Montgomery County, Prince George's County, and Washington County. Additional meetings are scheduled for later this, and I was in the second judicial circuit yesterday. And there's additional meetings that I have scheduled for later in October with Judge D. Leonardo and his colleagues in Carroll County. My goal is to meet with each jurisdiction every 2 years, and the meetings are a great opportunity to share sentencing guidelines information and updates, to discuss anything new that's going on with respect to the work of the commission, and finally to solicit feedback from the judiciary regarding sentencing guidelines and the work of the commission. The last thing that I would like to provide an update on is just to review the protocol for the December 2nd, 2025 public comments hearing. I'm sure most of you know the Sentencing Commission's enabling legislation requires the commission to hold an annual public comments hearing. And that hearing is an important opportunity to provide a forum to the public to discuss sentencing related issues. Our 2025 public hearing will be held on December 2nd. As those that are familiar, anyone who's new, the December meeting typically is a dual meeting. We will start with the annual public comments hearing, and then the second portion of the meeting will be a regular business meeting. Next month, a hearing invitation will be distributed to approximately 35 key criminal justice stakeholders throughout the state. And then further, we will distribute an invitation to roughly 1,000 criminal justice partners who currently receive the Sentencing Commission's notifications, and with respect to our guidelines, e-news, or any other notifications that we sent out. And our intention is to allow an option for those who are interested in speaking to do so virtually or in person. And then finally, I have a request for commissioners, as I do each year at this time. And that is specifically, I encourage each of you to think through and identify any thoughtful speakers who you think can speak directly to sentencing issues that are within the scope of the work that we do here at the Sentencing Commission, and to please feel free to suggest that any interested speakers may contact me if they have any questions about the public comments hearing, so we can get them signed up and registered to participate. So that concludes my report, and I'm happy to address any questions. Yes, Judge Shaw.
Maybe I knew this and I don't recall it, but I know we have a number of new judges in Prince George's County. So is that handled in baby judge school, or do they receive a separate how does that work?
It's an excellent question. So it's changed is the answer.
Okay.
It used to be handled in new judge orientation. And I actually used to participate in that training, but they reshuffled that training about 2 years ago. So there's no longer a sentencing guidelines orientation there. What we do instead is the judiciary provides an overview about the sentencing guidelines to new judges. And we reach out to each new judge as they are appointed. We send a letter to them. We provide them some basic information and just provide our website as a resource and encourage them to, contact us if they have any questions. But there's not a specific orientation about the guidelines anymore as part of the curriculum for the new judges orientation. I certainly would be amenable to doing it again. That was a decision that was over my pay grade when that was, reshuffled. And I'm
I think and I don't know, Judge Middleton, you may be better equipped to address this, but I think that now that we're doing so much training on Zoom, that it might be an opportunity to request that, because essentially you're providing training for the law clerks, but you're not providing training for the judges.
Yeah.
So
Yeah.
one thing too, Judge Shaw, we also started Crib Law University last year, and that is directed to new trial judges. So I can make that suggestion.
Thank you. And one last thing, Dr. Sule, I want to make sure that the decisions that we made today are communicated like immediately to the assistant state's attorneys who spoke to us, because I want them to understand that we were receptive to their comments and that we really did a deep dive, so that in the future, if they have additional requests, they'll feel comfortable bringing that to us.
Yeah, I think that's an excellent point, and I will absolutely plan to follow up.
Thank you.
All right. Thank you. Any other comments? All right. Moving on in the agenda, is there any old business? Any old business? Hearing none. Is there any new business or announcements? Hearing none. Do we need a motion to adjourn? I don't think we need okay. Sometimes we do.
Yeah, you could do it. I don't know.
All right. Do we need okay. Is there a motion to adjourn?
Move to adjourn.
Thank you, Mr. Finch.
You're welcome.
Okay.
And a second if you need it.
We don't need,
It
I
was
don't think
second.
we need it. All right. All right. This meeting is adjourned. Thank you everyone for your time
Thank you.
tonight. Wonderful meeting. Wonderful job, subcommittee. Thank you.
Thank you
Thank
so
you.
much.
Thank you.
Good night, all.
you.
Good night.
Night.
Bye.